is the judicial system that interprets, defends, and applies the law on behalf of the state. The judiciary can also be viewed as a vehicle for resolving disagreements. The judiciary, according to the idea of the separation of powers, does not originate statutory legislation, which is the role of the legislative, or enforce law, which is the responsibility of the administration, but rather interprets, defends, and applies the law to the circumstance of each case. In certain nations, however, the judiciary creates common law. The judicial branch has the authority to amend legislation in many jurisdictions through the process of judicial review. Courts having judicial review authority may overturn state laws and norms if they are found to be incompatible with a higher standard, such as made legislation, provisions of the Constitution, treaties, or international law. The judiciary is the government's third branch. It is responsible for applying the laws to individual instances and resolving any disputes. From the perspective of the citizens, the judiciary is the most important arm of government since it protects them from the potential excesses of the legislative and executive branches.
Malaysia is known for its remarkable event in 1988, issues such as the High Court judge declaring the ruling party to be an illegal society. However, this event indirectly led to executive interferences against judiciary, resulting in the removal of Tun Saleh Abbas, the Supreme Court President, also known as the Mohsin Estate, and the two other Supreme Court judges. The election of the United Malays National Organisation UMNO, which is the dominant political party of the Barisan Nasional Malaysia in 1987, was the beginning for a series of events for the 1988 Malaysian constitutional crisis. It is also known as the 1988 judicial crisis. Additionally, as years passed by around 1988, the Supreme Court had led their way in being more independent of other branches of government in Malaysia. The story begins in a most unlikely way. The president of UMNO in 1987 was the Prime Minister of Malaysia, Datuk Seri now Tun Dr. Mahathir. He had received about 100 nominations from UMNO supporters for him to be the UMNO president. Therefore, his challenger at that time was Tengku Razali, who was one of the vice president of UMNO. However, he received few nominations from UMNO branches compared to Datuk Seri Mahathir. He remained brave and enthusiastic to launch the challenge, where at that time his decision had surprised many. After that, when the secret ballot was counted, Datuk Dr. Mahathir only won a slim margin of 43 votes. This has come as a shock to many, as they thought he would win by a large number of votes through various branches of the party. Furthermore, the 11 UMNO member, or it can be referred to UMNO 11, have filed a civil suit in the Kuala Lumpur High Court. They applied for several relief, including permission and a declaration for the entire election of office bearers during the UMNO General Assembly in 1987. They described the assembly of unconstitutional and illegal. Therefore, it is considered void. Through that, they have agreed to a list of 13 unapproved branches. However, each branch can elect 5 delegates, where each delegate represents 50 members based on the UMNO constitution. It is because each member of each division may have paid the annual fee before 31 December of the previous year. Additionally, Datuk Harun Hashim, the High Court judge, ruled that UMNO was an organisation that had violated the law. Those who are members of UMNO, or known as UMNO 11, do not have and cannot get any rights over every matter that is illegal. Therefore, because of that, the court did not allow them to appeal, and he has dismissed their claim. It is clear that the order given by the High Court judge is an order and not sought or applied for by UMNO 11. Besides, Tun Saleh Abbas, who is also the president, was suspended after UMNO 11 appealed to the Supreme Court of Malaysia. He was not allowed to carry out his duties before the UMNO 11 appeal was decided by the court. However, Abu Talib Othman, the former Attorney General, said that there was no judicial crisis in 1988. He stated that judge had the right to rule, so when they were criticized, they wrote a petition to the king to inform them that the executive had encroached on their powers. He also questioned why they could not be criticized. The former Prime Minister at that time, Dr. Mahathir, said the party will help the judiciary to gain independence if the opposition took their place. Due to this, many parties are dissatisfied with Dr. Mahathir because of his action that abolished the separation of powers of the legislature when he was a Prime Minister from 1981 to 2003. Furthermore, he thinks that if there is even a judicial crisis, it only happens among judges because only the judges have the great power. If the judges does not do a petition to the king, Saleh Abbas will not be suspended. In short, this crisis is not something different to Commonwealth countries of the Asia. The judiciary is still in the process of exercising the freedom and trust granted to them by the constitutions. Through this matter, we can see the difficulties experienced by the judges in this fast-paced country in conducting and resolving political as well as legal problems.
4 factors to ensure the independence of the judiciary in Malaysia are stated in the Federal Constitution of Malaysia. Firstly, the factors to ensure the independence of the judiciary in Malaysia as stated in the Federal Constitution of Malaysia is the selection of judges. The selection of judges is very important. The value of a judge is highly dependent on the effectiveness and independence of the judiciary. There are 3 ways to approach judges, which is through legislative elections, popular elections and executive election. In Malaysia, the selection of judges usually by executive selection. According to Article 122B Clause 1, it states that the Chief Justice of the Federal Court, the President of the Court of Appeal and the Chief Justice of the High Court, as well as the other judges of the Federal Court, Court of Appeal and the High Court shall be appointed by the Yang di-Pertuan Agong. Yang di-Pertuan Agong, who is going to act on the Prime Minister's advice and after consultation with the Conference of Rulers. There are criteria for judges of the Federal Court, Court of Appeal and High Court. If a person obtains these criteria, he is eligible for appointment as a judge of the Federal Court, a judge of the Court of Appeal, or a judge of any High Court under Article 123. One of his criteria is that he be a Malaysian citizen. Furthermore, he must have been a court advocate or any of them or a member of the Federal Judicial and Legal Service, or one or more of them during the 10 years preceding his appointment. Another component that ensures the independence of the judiciary in Malaysia, as mentioned in the Federal Constitution of Malaysia, is judiciary tenure. The judiciary is an important element of judicial independence and a crucial concept in upholding the rule of law. Judges cannot be sacked solely on the preference of the highest executive after they have been appointed. This is due to the fact that judges must serve until their term expired unless they are implicated in corrupt and immoral actions. According to Article 125 Clause 1 of this article, a judge of the Federal Court shall hold office until the age of 66 years or more. Next is must be no later than 6 months after he attains that age, as Yang di-Pertuan Agong stipulates or got approval by the Yang di-Pertuan Agong. Thirdly, as mentioned in Malaysia Federal Constitution, the salary of judges is also an important aspect in ensuring the independence of the judiciary. Salary is a predetermined payment made by companies to their employees for a certain job. It can be paid monthly or annually, but it is most commonly provided monthly, particularly to employees, managers, directors, and experts. Judges should be compensated in accordance with their role. In Malaysia, for example, the anticipated basic compensation for a judge is RM26,500. Next, in addition to their pay, judges will be paid a relatively significant allowance. Entertainment allowance, housing allowance, subsidy and special judicial allowance are some of the allowance that will be earned. a judge's salary would be applied to the consolidated fund according to Article 125 Clause 9. According to Article 125 Clause 7, a judge's income and other terms of service, including the right to a pension, cannot be converted to his loss after his appointment. Lastly, no involvement from any executive body of the legislature is required to ensure the independence of the judiciary of Malaysia as stated in the Federal Constitution of Malaysia. According to Lasky, if the executive can make the court rulings based on his own preference, he will complete control over the state. The executive body should not compromise the powers of judiciary and should act prudently when conducting the functions such as judicial appointments. According to Article 127 of Malaysia Constitution, the acts of a judge of the Federal Court, the Court of Appeal and the High Court should not be mentioned in any House of Parliament except above structural changes in which a notice has been obtained by not less than 1/4 of the total amount of members of the House, and it will not be mentioned in any state legislative assembly.
Now, I am going to present about the functions of the judiciary. So, the primary function of the courts is to ensure the administration of justice. Courts are institutions for resolving disputes between individuals and between citizens and the state. While giving judgment on cases, the courts also perform numerous functions other than to settle disputes. They perform the following functions such as establishing facts, create new laws, preventing infraction of laws, and judicial review. First and foremost, the function of the judiciary is to establish and determine facts. It is important because when a case brought into the court, it commonly remains ambiguous. The court plays a vital role in determining the facts of the case in order to deduce the truth. The procedure that will be followed is for the disputing parties to present witnesses. This procedure is important in order to generate the evidence which will support their respective claims. The evidence can be presented in orally, writing, or both. The judges will hear those witnesses and wait their testimony. Lastly, the fact will be determined based on the evidence. For example, in Malaysia, we have death penalty for drug trafficking. Distribution of drugs in excess of the prescribed amount is one of the offences that can result in a death sentence. If a person is accused and found guilty of such activities, he will be sentenced under the offence of drug trafficking and smuggling, Section 39B of the Dangerous Drugs Act 1952. Furthermore, judiciary are responsible to create laws. It is because laws are made to address with broad issues. For example, there are various categories of crime in the world such as cybercrimes, sexual crimes, and drug crimes. However, when dealing with a specific case, the existing laws may appear to be ambiguous. It is because they may be worded in such a way that determining their exact meaning could be difficult. Owing this, it is crucial to develop a new law that addresses the issues in order to resolve the dispute. For example, the COVID-19 pandemic has been widely spread in Malaysia in 2020. On December 2020, the Sabah state government has proposed that a bill be enacted to establish appropriate provisions and measures throughout the COVID-19 period in order to reduce the spread of the viruses. The bill on temporary measures to reduce the impact of coronavirus diseases has been enacted as a commitment by the state government to minimize the impact of the COVID-19 pandemic, which has had a direct impact on the economy, society, and industry in Sabah. So the third function of judiciary is to prevent violations of law and the violations of human rights. In Malaysia, the Domestic Violence Act 1994 that provides protection for the victims of domestic violence. However, parties or individuals are not required to wait until their rights have been violated. To exemplify, when the perpetrator threatens the victim with intent of causing the victim to fear for his or her own safety, or the safety of his or her property, to fear for the safety of a third person, or to suffer distress. Owing this, if they have reason to believe that their rights will be violated, they can approach or appeal to the court for protection before the actual violation occurs. Following that, the courts will issue orders prohibiting such attempts until the parties' rights are determined. For example, while filing a police report, the victim can apply for an interim protection order (IPO) to protect themselves and family members such as children, fathers and mothers from the perpetrator who is committing domestic violence against them. Last but not least, in a democratic country, the courts have the power of judicial review. It refers to the power of the court that's specifically designed to declare any act of the public bodies null and void. This action will be taken if the public body's decisions, actions or omissions are found to be violation of the Constitution. Prior to 1996, Malaysian courts referred to the strict and technical common law rules that govern judicial review of administrative actions. The judicial trend, however, has shifted from referring to the common law rules to the Federal Constitution. So that is all from me. I will pass to the next presenter. Thank you.
Next, the structure of the Malaysian judiciary. There are two classifications of courts in the Malaysian judiciary, which are the superior courts and the inferior courts. The superior courts consist of federal court, court of appeal and high court. Meanwhile, the inferior courts consist of session court and magistrates court. First and foremost, the Federal Court. Federal Court has been constituted under the Article 121 Clause 2 of the Federal Constitution and Part 4 of Courts of Judication Act 1964. It reinstated the Supreme Court under the 1994 Constitutional Amendment, and it is the greatest version of Court of Appeal. These are the composition of Federal Court. However, it is ordinarily being sat in bench of 5 judges, yet for crucial multiplex and extraordinary cases, it is being filled with bench of 7 judges. Besides, the appointment of Chief Justice is by Yang di-Pertuan Agong YDPA with the Prime Minister PM recommendation, and the appointment of 11 Federal Court judges is by Chief Justice after consultation with the PM. Next, there are several jurisdictions of Federal Court. Firstly, the original jurisdiction of civil and criminal events. Secondly, the appellate jurisdiction, which it will be perceiving civil and criminal matters from the appellate jurisdiction provided by Court of Appeal. Thirdly, the revisionary jurisdiction, as it may determine the constitutional provisions which have arisen in any courts. And lastly, the advisory jurisdiction, as it may give judgment on any inquiry mentioned by the YDPA on any provisions of the Federal Constitution. Other than that, the second superior court is Court of Appeal. It has been constituted under the Article 121 Clause 1B of the Federal Constitution and Part 3 of Courts of Judication Act 1964. These are the compositions of Court of Appeal. Besides, the appointment of the President and the judges is by the YDPA on the advice of PM. Then the Court's authority also includes civil and criminal appeals, as it will hear and resolve criminal appeals that are adverse to any decision made by the High Court, as well as civil appeals from the High Court for incidents involving a claim of more than 250,000 ringgit Malaysia. Additionally, the last superior court is High Court. It has been created under the Article 121 Clause 1 of the Federal Constitution and Part 2 of Courts of Judication Act 1964. These are the compositions and appointments of High Court. Next, one of the jurisdiction of this court is the original jurisdiction, as it has both criminal and civil powers. Secondly, the appellate jurisdiction, which High Court hears the magistrates and session courts criminal and civil appeals. Thirdly, the revisionary and supervisory jurisdiction. Next, let's move on to the inferior courts. First and foremost, the Session Court, which has been entrenched under Section 59 of the Subordinate Courts Act 1948. These are the compositions and the appointments of Session Court. Next, there are two jurisdictions of Session Court, which are the first one is original jurisdiction over criminal and civil matters. The second jurisdiction is supervisory jurisdiction, which it has limited supervisory role over the magistrate court. Last but not least, the magistrate court is one of the inferior courts. In Malaysia, the magistrate courts are the last and least ranked in the hierarchy of courts, and they are more numerous than any other country. The magistrate court has been constituted under Section 76 of the Subordinate Courts Act 1948. These are the compositions and appointments of magistrate courts. Next, they have a jurisdiction which deals with minor civil cases and minor offences in everyday matters as well. For example, offences that related to the use of motor vehicles, breach of regulations, and small claims.
To sum up, jurisdiction is primarily a substantive issue. It impacts on a state's sovereign decision as to the methods of settlement it believes appropriate for the resolution of an international dispute with another state. The responses it selects would have a direct influence on the resolution's outcome. Following that, the judiciary is also involved in lawmaking. The judiciary participates in the legislative process as well. The meaning, substance and scope of the laws passed by the legislature are all defined by court judgments. The interpretation of laws by the court amounts to lawmaking because it is these interpretations that genuinely define the laws. Judicial decisions are a source of law. Individual judges and the judiciary as a whole must be impartial and independent of all external forces and of each other in order for persons who appear before them and the general public to have trust that their cases will be judged fairly and in line with the law.